Welcome to First Amendment Auditing Urban Legends Part 5. Today's urban legend that I see in comments so often is that, well, the cop said X or the cop said Y, as if that means a damn thing. Cops can lie. Cops do lie. The objective of the police officer is to get you to incriminate yourself. If you incriminate yourself, you've made his job a whole lot easier. And to get you to do so, he can lie to you. He can tell you half-truths. He can say, well, partner, it'll go a whole lot easier if you just do X, Y, or Z. And they do that because some people are dumb enough to go along with them. So for everybody who puts in the comments, when I make a judgment about something, well, the officer said X, Y, or Z, I'm going to instantly discount it because the officer is not under oath. The officer is not facing any repercussions for lying. It's a well-known fact that officers lie. I mean, think about every undercover officer you've ever seen. They are lying to you. They are lying to you by pretending to not be officers. Officers can lie to you. Officers do lie to you. Officers will lie to you. An officer saying that he's not suspecting you of a crime doesn't mean the officer isn't suspecting you of a crime. Now that I've gotten that little bit out of the way, lies can come in all sorts of shapes and sizes. Like this fat tub of lying, like this fine officer from the Hickman, Kentucky City Hall video by Juju68. An excellent video if you want to be very frustrated with both the auditor and the police. From someone in my position where we're looking at the law, it's always very frustrating to see someone go on what they think the law is going to be. Now this Juju68 fine fella, he thought he was under an obligation to give his name. And he probably thought he was under some sort of an obligation in Kentucky to give his name upon detention, is because the Kentucky government said, you know what, you probably should. Now, sadly enough, this is in the Department of Public Advocacy website, you know, where they try to help indigent people and people who are trying to go pro se or who are going to get public defenders. They say the only information that you must give the police is your name. Well, the ACLU of Kentucky thinks that they're full of crap. In Kentucky, you do not have to give your name if asked to identify yourself. So how do we solve this? Well, I always recommend whatever state you go to, you talk to an attorney. If you're finding this video at some point in time, just remember circumstances may have changed from when I made this video. New laws get passed all the time, so just talk to an attorney. First thing we have is Kavanaugh v. Commonwealth. In Kavanaugh v. Commonwealth, Kavanaugh was the passenger in a vehicle. The officer pulled him out, demanded his identification. Kavanaugh refused. The officer patted him down, pulled out his wallet, and started fishing through his wallet. Well, long story short, Kavanaugh was an idiot and got into a physical altercation with the officer, which promptly got him arrested, not only for assault, but for a half a gram of crack that was not in his wallet, but was in his right front pants pocket. But the court had to determine whether or not there was some liability on Kavanaugh to identify. Now, this is the Supreme Court of Kentucky, which would be the ultimate arbiter on whether or not Kentucky has a law requiring you to identify. And they said that after identifying pertinent federal and Kentucky law, we concluded that the Commonwealth of Kentucky is not a stop and identify jurisdiction. Therefore, absent a statute requiring disclosure, Kavanaugh could not have been arrested and prosecuted for failure to provide identification. However, since an officer is constitutionally permitted to request identification, any failure to comply may still be considered along with other sufficient factors demonstrating reasonable suspicion. Remember, reasonable suspicion is a totality of the circumstances kind of test. So, yes, not giving up your ID is a factor. It's not dispositive, it's just a factor in determining whether or not they have reasonable suspicion to stop you. Now, if they are looking for a particular person and they think you might be that particular person, you not wanting to identify would heighten their suspicion that you're that particular person. If you're filming at a city hall, your ID isn't going to give them any pertinent information about why you're filming. So it is less grounds for reasonable suspicion in that particular instance. And also you want to go through the Kentucky penal codes. I went through all of them. I can't find anything supporting the statement made by the Department of Public Advocacy that you must give the police your name. So I'm thinking the ACLU probably has the right end of this. This was a 2014 decision by the Supreme Court of Kentucky. I haven't seen any changes, so I'm not saying that is current law, but all the lawyer attorney websites in Kentucky all say that you don't have to cough up ID. And then finally, I want to play a little bit of this, not because I'm only going to play a little bit post arrest, so I'm not going to try to spoil too much, but I just want you to listen to this idiot talk. I'm not going to play it quite that fast. I want you to understand it.
Complaint?
Yes.
Police?
Yes.
I'm the chief of police.
Okay.
The only other place.
I'm the chief of police. Yeah, there's only one police officer in the town. Filing a complaint, it's not really going to get you too far, especially if you're not a resident of the town. But a town that small sure can't afford to pay out a settlement, can they?
So be City Hall.
City Hall?
Yeah. What kind of complaint are you wanting to file?
What kind of complaint are you wanting to file? This smacks to me of an officer trying to intimidate somebody who wants to file a complaint.
Well, right now, illegal detainment.
Well,
Listen to this. Listen to this. Now remember, the only way that an officer can do a Terry stop on you is if they have reasonable suspicion you've committed a crime. This officer was not able to articulate any suspicion of a crime. The length of detention is a factor, obviously. You can't detain someone for a long period of time on a Terry stop. And of course, long is subjective, and that's something that a court will take into account. But you still have to have that reasonable articulable suspicion that's particularized and not inchoate about what crime you think this photographer may have been committing. And this videographer, is very soft-spoken, very well-mannered. He seems like a really cool dude, and I have no idea why they reacted to him this hostilely. Maybe this guy was having low blood sugar or something. But he's making the argument that the time he was detained is somehow relevant.
I've only been here 10 minutes, with me, maybe 12.
Yeah, 10 minutes or maybe 12 minutes of illegal detention is still 10 to 12 minutes of illegal detention. But please, do go on.
I have a reasonable right under your constitutional rights.
I have a reasonable right under your constitutional rights. This is the example of hiring done under the ADA. This guy is most likely clinically retarded.
To detain you for a reasonable amount of time, I think 12 minutes.
For a reasonable amount of time if you have reasonable articulable suspicion. It's not the amount of time, you inbred moron.
To see why you're, maybe 15 minutes to see why you're videoing a government building and everything.
To see why you're videoing a government building. That's not a crime. Again, he's still, even after 10 to 15 minutes of detaining this guy, this officer still has no idea what crime he may have committed. So that's all I'm going to do today. I also want to point out that at some point in time, there is a Terry stop where the officer does lay his hands on him, and he can, if you're not cooperating, the officer can escalate to use a reasonable amount of force, and that's for a trier of fact to figure out. But he goes through this fine fellow's wallet. Does it say it right here? Yeah. So, okay. Come on. I was detained for about a 10-minute period. I think I was ordered to lean on the trunk of his cruiser and keep both my hands on the trunk where he could see them while he got my wallet and pulled my driver's license out and ran it. A Terry stop allows them to pat you down for weapons. The purpose of a Terry stop is officer safety, to allow them, if they have a reasonable articulable suspicion that you're committing a crime, and they have a reasonable articulable suspicion that you may be armed, then they can pat you down for weapons. A wallet is not a weapon, nor is a driver's license. In order to do a search, you have to be arrested. There has to be an arrest. And obviously, probable cause is a much higher standard to meet than reasonable suspicion. If he's failing reasonable suspicion, he's failing probable cause. If it was an arrest, he could pull the wallet out. He could pull the driver's license out. He could do a full search incident to arrest. He didn't do that. So normally I don't jump all over this was an illegal detainment, but this, my friends, was an illegal detainment. Anyway, I hope you enjoyed it. Remember, the cops can, will, and do lie to you. Apparently, the Department of Public Advocacy for Kentucky also has no qualms about lying to you. I would be more likely to trust the ACLU. I think they have your rights more in mind. And the Supreme Court of Kentucky obviously would have a pretty decent grasp of what the law is, and there's nothing in the Kentucky Penal Code requiring you to ID. However, if you do give them your name, if you give the officer a false name, that is a crime. So if you're thinking about giving a false name, please don't. Just keep silent. Thanks, and have a great day.